Dean Skelos refusing to take the stand in his federal corruption case. Shelley Silver used the same strategy. That didn't work out too well. Our panel of lawyers is here to weigh in on the strategy. Then, the Supreme Court taking up two cases that could change the way that people vote and also who goes to which colleges and who don't. They're big cases with huge implications. Then, former USC head football coach Steve Sarkisian is suing his school for, he says, being wrongfully terminated. But the reason why is fascinating. He claimed he was discriminated against because he had an alcohol problem, which is considered a disability. I'll ask the table if he actually has a case. Good evening and welcome to RFL. I'm Richard French. Thank you very much for joining us tonight. And we begin this evening with a Dean Skelos corruption trial. It looks like the jury could get the case as early as tomorrow. And Dominic Carter, he's live in Lower Manhattan covering it as he has since the very beginning, and he joins us now live. Dom?
And good evening to you, Richard. You wouldn't believe the amount of media that arrived here this afternoon. This, as the case is definitely going to the jury tomorrow morning. Could you please just repeat what you just said?
I said that from the beginning, I have absolute confidence in our judicial system. We have a very attentive jury that I believe will render a verdict of innocent.
The case has reached the end, Richard. In closing arguments, the attorney for Dean Skelos, Robert Gage, said, quote, "When you look at it as a whole, it's not a conspiracy. It's a father going through ups and downs with his son. At the core, at the bottom of this, is that nothing was traded here. You know that from the evidence. Nothing was exchanged." Then he took on, if you will, the elephant in the room, the issue of Dean Skelos' son, Adam, and the devastating wiretaps prosecutors played over and over. Talking about Adam Skelos, he said, quote, "He's volatile. He's prone to saying things, prone to exaggeration." With U.S. Attorney Preet Bharara in the courtroom today, the prosecutors hammered away. I don't care how generous a boss is.
So, Richard, it all begins again.
No one would tolerate an employee like Adam Skelos unless they felt they had no choice. Just a short time ago, Judge Kimber Wood started charging the jury. And Richard, she said, quote, "It is not necessary that the conspiracy succeeds in its mission." Minutes ago, amidst a ton of media here, Adam Skelos was not in any mood to answer our questions.
Can you just give us a reaction of how you feel?
Defense today, Adam? Adam, you've been looking really good in court.
So, Richard, what's going to happen in the morning? Judge Wood had promised the jury that she would have them out of here by 5 o'clock today, 5 o'clock today. So she started her charge and then dismissed them. So for the first couple of hours, maybe an hour and a half or two, in the morning, the judge will continue her charge, her instructions to the jury on how to proceed with this case. And then, Richard, it's in their hands. Reporting from Lower Manhattan, I'm Dominic Carter. Let's go back to you.
You know, Dom, I'll get into this to the panel, but so many parallels to the case that just finished across from where you are in Foley Square. No defense put up by the Silver case, and the instructions seemingly given by the judge said you don't have to connect the dots here as it related to the quid pro quo with Silver. In this particular case, didn't matter if the money ended up getting in the hands. If the intent there was, in effect, to defraud or, in this case, use influence to line the pockets, that's enough. It sure looks like the Skeloses have even a tougher hill to climb than even Silver did.
Well, Richard, I'm glad you brought that up. Your assessment is 1,000% correct. The charges from the judges thus far, because Judge Wood is going to continue, they appear to be similar in terms of using your words, basically paraphrasing. You don't have to complete the act. The question is the intention. And based on that definition alone, wasn't good for Sheldon Silver, definitely not good for Dean Skelos or his son. It's going to be very interesting to see how this all plays out. But the bottom line from talking to consultants, pundits, lawyers, no matter how you slice it, it doesn't look good for Dean Skelos. But who knows what the jury may actually conclude, Richard.
All right, Dominic, good enough. Thank you, and I know you'll be there tomorrow. All right, let me bring in the panel right now. Jim Koussouras, criminal defense attorney in Manhattan, sitting on the board of directors at the New York City Criminal Bar Association, frequently lecturing at New York Law School and the bar associations in both Queens and New York City. Doug Von Oys, founding partner of Carson Von Oys, focusing on corporate misconduct, selected by the Legal 500 as one of the most influential trial lawyers in the nation. Mayo Bartlett, he's an attorney at the law offices of Mayo Bartlett PLLC and former chief of the Bias Crimes Unit at the Westchester County DA's office. And Mark Furnish, professor at Brooklyn Law, has argued before the U.S. Supreme Court, and we'll be talking about the High Court a little bit later. Okay, I know no two cases are exactly the same, Jimmy, but if we learned anything from the Silver trial, it was that there is distaste, not just in jury boxes, but pretty much everywhere, for Albany and the elected officials. You have wiretaps. You have more smoking guns in this. You have very unlikable defendants. Even if you feel sorry for the dad, you look at the son here, there's no way around it. Why not? I know it could make it worse, but at this point, how much worse? Why not put up any defense? Would it kill you to put the dad on the stand and try to explain that, somebody, maybe one out of the, 12, can relate to having a mess up for a kid, and you do anything to try and help them, fall in the sympathy of the jury? Is there any strategy to just saying, we rest, it's in your hands?
Well, there's an expression, I'm probably going to get it backwards, but it is the defense case never got better after the prosecution rested. It is very rare that we put defendants on the stand because, that type of thing would require an admission. It's almost like, yeah, I did it, but my kid is this or my kid is that, and I wanted to help him out. In these cases where there are going to be legal, technical questions on the law, less here, I think, than in the Silver trial, you rest on the record and you play to the Second Circuit, and hopefully you play to the jury that very thing. There's a difference between the Silver case and this case. The Silver case, you're talking about $4 million. You're really talking about, you give me this, I'll give you that. And here, I think the question and the question for the jury is, was there an exchange or was this a favor? The employer is going to say, I had no choice but to keep him. Well, was that because anybody told you that, or was that because it was in your head?
Okay.
And the kid's got a big mouth, and he's obviously got issues.
I get that, except...
I'm not saying it looks good for him.
I hear you. But in the Silver trial, in cross-examination, Dr. Taub and others, they said there was no quid pro quo. So it was basically to the jury to divine whether or not it was the intent here for Silver. He certainly enriched himself. Okay, but there was a reach. I didn't think they found him guilty on all 7 counts, so what do I know? In this case, anybody listening to the wiretaps, it's cringeworthy. And moreover, everybody that was brought up from Al D'Amato, for crying out loud, who said, I wouldn't hire that kid with, if you paid me, which basically was what they were asking him to do. And more than that, he was a disaster in the office, putting pressure on people. The guy had to tell him, read the papers. The guy's, I think if Bahar is listening, basically daring the U.S. Attorney, I can't make this worse than it is, Doug. I hear it all. But they have case law in effect to go off of from what happened last week. Something's better than nothing, no?
No, because I think they're probably looking towards the appeal at this point.
On what grounds?
Well, they don't really have much of an appeal. They do have the one precedent, the issue of whether it was an official action taken by the father, and that's McDonald's issue. So that's still pending before the Supreme Court. The Supreme Court hasn't decided whether it's going to hear that case yet. Actually, the guy who has the better appeal right now is Silver, based on the existing Second Circuit precedent. He has to hope, Skelos does, that the Supreme Court A, decides to hear the McDonald case, and B, changes the law as to what constitutes an official action, because he didn't really, it was the soft use of his official position that got the kid the job.
Well, it was a little bit more than that. If
well,
you
he wasn't
believe
performing a legislative function, that's the point.
But explain instruction, okay? Because the instruction to the jury was very important in Silver, and it's very important here in Skelos.
But they're different.
They are different, but what they basically said was, hey, if he intended, Dean Skelos intended to basically use his office here to influence other people's decisions.
If the bribe payer and the bribe recipient, in this case the father, had an understanding that it would be so used, that's sufficient. And all that instruction is saying,
to prove it.
All that instruction is saying, if the offer is made and accepted, doesn't have to be carried out. That's all the instruction is saying. That's a different question from whether the use of his position constitutes an official function as a matter of law. And right now, under Second Circuit law, the governing law here, it clearly does. So he has no appeal at this point on that ground. And the rest of the pretrial motions, it's really not
Mark,
that complicated.
I mean, there
legally.
are, I mean, just because that case is pending, and I agree with you, there's always another case. It's not like this is a run-of-the-mill case where you have this.
Look, this is a bad, you would think the other two cases in the trifecta, right? Smith had some tapes, not like this. No tapes in Silver, much murkier factual situation. This appears to be the worst of all the cases because, as the adage goes, you can't cross-examine a tape. But to Rich's point, you know, the jury can deduce the fact that he's doing this on behalf of his son and that he's a beleaguered father, maybe he had good motives. They can deduce that without anybody getting up on the stand and opening themselves up to cross-examination on all the other bad things that he's done, some of which were kept out by Wood before trial.
Man, I got a couple technical
And that
questions,
could
really
throw a monkey wrench in it.
which is, first off, are you surprised if you were the Skelos team, you didn't try and work out a plea? I understand, I don't know the terms of it, but there was a plea deal that was offered in the Silver trial. He walked away from it. In the case of Skelos, we've heard that they were trying to get one, they couldn't get it. Complicated because you got father and son. Who's going to fall on the sword for whom? Who do they really want? Even if the kid went, they still got to make the example of the old man. Are you surprised that didn't come out to play here?
Not necessarily, and that's an interesting dynamic because what it's also suggesting why you may not take the stand. Sometimes, especially in state court, it would be a lot easier. You conference the case with the judge, let the judge know, look, Judge, we'd love to resolve this case, but the prosecutor's not giving us anything. In federal court, you really don't get a conference with the judge where they indicate a sentence. So here, a lot of the reasons that you may not testify is that you don't want to subject yourself to a possible perjury. Secondly, you want to be able to, on a sentencing date, appeal for leniency and say, listen, we didn't get in there and mislead anybody, Judge. More or less, we would have accepted responsibility. We're under no obligation, however, to testify. So by not doing that, you're not putting yourself in a position where now your testimony is going to be scrutinized when you're asking for acceptance of responsibility points off.
But the guidelines that he's looking at, yeah, I'll get to that in a second.
He's right. We're
That's
not
why-
talking
that's why-
about
that he's
normal
right, he's
defendants
right. That's
here.
right.
These are the kings of the universe. They're going to trial. They have egos. This is, you know, no, I'm
his
not
life-
pleading
Sometimes
guilty.
you go to trial also, and look, we've all done trials, especially in federal court. You have no option because if you go to trial, your client's facing life. They're facing 10 or 15 years. So you go to trial.
With you as their lawyer in front of a judge like this, you have 3553. The guidelines are advisory.
Yeah.
And in front of a judge like this, Skelos getting up and saying, it was wrong, but I've had this kid on my back for years. You can just listen to. I would play the tapes for the judge during the sentencing hearing and saying, look at what I'm dealing with.
You're right, Jim, but the only other thing
So
is
you
that
had
we
an
don't know what
they were offering.
We don't know what they were offered,
Right.
and the other thing we don't know is that we have to look at the fact that this is part of a trifecta. So this is a unique situation. It's not a case standing by itself, so there's going to be a lot of pressure on the judge also in terms of
but
sentencing.
here's the thing, and I know you guys hate criticizing other defense attorneys, okay? I get that, all right? But I've heard from a lot of attorneys who aren't on TV doing this saying, Mola could have done a bunch of other things here than he did in the Silver case here. And maybe in the Skelos counsel, they were dealt a terrible hand. There was a little bit more limiting than they did. Again, Monday morning quarterbacking a little bit, at least as related to Silver. First of all, if you believe, at least every rumor I've heard, and maybe it'll still come out before we get to the sentencing, he could have flipped on some people. He had something to trade, one would think,
But he
after
has
40
to-
years
but
in the
he's-
I
assembly.
would take out Jimmy's note again. He's a 70-year-old man. What's
So he's
going
looking
to
at
be his
20
epitaph?
years at
The
least
epitaph is now going to be that. But if he didn't do ego,
I'll save
but
it,
if,
yes.
if he didn't do that, though, his epitaph, he's going to be remembered. His life's work is down the toilet. These people exist to leave a legacy. If they
You
don't
wanna
go to
die
trial,
in
But the
jail,
other
though?
thing, though, is at 70 years old,
He's
you may
70 years
die.
old.
You may die in jail if you get a 5-year sentence. So
That is
it's
true.
it's not like you're really giving
Wouldn't
up
you
that
rather
much
be looking
more.
at 71 at 5 instead of 20?
I think that Jimmy is totally right.
Oh,
These
you look
people,
at the guidelines. You
He's
know,
not getting 20.
you don't think he's getting 20?
No, there's
No,
no way
no,
he's
he
getting
won't get
20. I mean,
That's
you
a
know, listen, the
statute-
guy
those are
has done a lot of
statutory
good in his
maximums.
life, and you know something? A judge has to look at this and at least think about all of the things that we've been talking
I know,
about.
but
in
there is a
terms of-
vacuum. There is
Yeah.
a vacuum right now where there is such antipathy. And I'm sorry, at the end of the day, The guy put $4 to $5 million in his pocket.
Well, she's
okay?
going to
and
be a very tough
he
judge
used his
on the Senate.
office
Caproni
and he
will be a
used his
very tough
position
judge on the
to
Senate.
certainly enrich himself.
Can I ask
Caproni
you guys
will be
something?
very tough.
Can I ask you that in all of our jobs, what you do, what all of us do, how many judges call and get their kids jobs at prosecutors' offices? How many? And again,
But
I'm
that's
not.
different.
I'm not,
Yeah,
It's
but they
different,
had
Jimmy.
legislation
I'm sorry,
pending.
I'm
they had-
sorry.
No,
You're a judge.
They had
and you're
legislation
asking-
that was pending before him, and they shook them
I
down
got
for
you.
more
I
money
got
while
you.
he was
Huge
there.
difference.
But
He's got his dad on the phone saying,
know
Dad,
what
give
it
me the
is?
names of the billionaires.
We're going to
You
be
know,
talking about it
you
down
know
the
I
road,
think
but
the case is bad.
It's
You
the
know I
ultimate
think the
form
case is
of
bad.
affirmative action. That's
You
what
know
it
I
is.
think the case is bad.
Look at you. This is why I love Nick.
reverse
He's
affirmative action.
segueing. All right.
Yeah, that was
now,
brilliant.
the Supreme Court is looking at a case that could sway elections. Is a really big case and actually redefine the meaning of one person, one vote. Talk about that after this.